Good day, everyone. Welcome once again to Law Cora. This is an interactive podcast where we discuss law related issues, discuss law courses, and share our legal opinions. So, if you are listening to this podcast for the first time, we highly welcome you and we hope that you enjoy our discussions in this podcast. So, my name is David Njoku and I'm the CEO and founder of Law Cora. And setting up this podcast was for educational purposes and to share legal ideas with anyone who may be interested in knowing more about the law. So, in our last episode, we discussed on legal research. We discussed on sources of Nigerian law. We discussed on the various meanings of the sources of Nigerian law and also the sources of this law. We discussed them in detail. So today our topic would be on legal research. So we'll be discussing the meaning of legal research and the process on how to conduct legal research in a law library. So first and foremost, we need to know what a research is. Now, a research is an inquiry, a quest to acquire more knowledge on a particular topic or field or aspect or in a particular subject. Research is the art of wanting to know more, wanting to gain more knowledge, more insight on a particular topic. So bringing that definition into the legal field, one would simply say that legal research involves the process of retrieving information in order to arrive at legal conclusions or to make legal decisions. I repeat, legal research involves the act or the process of retrieving information in order to arrive at legal conclusions or give legal decisions. So, legal research is very important for one to become a sound lawyer. You can't become a sound lawyer if you do not know how to conduct a proper legal research, because it is with legal research that you'll be armed with the law and you will know what is applicable at that particular time and in that particular jurisdiction. So legal research is very vital and very, very important. And a lawyer who does not know how to conduct a proper legal research cannot be able to make well organized presentation of his or her cases, because it is with legal research that you'll be able to understand other aspects of law that you may have not been aware of. Legal research expands your knowledge, and so legal research is very, very vital and very, very important, not just to the lawyer but also to the law students and those who are interested in knowing more as regards the legal field. So legal research is very, very important. And this legal research is of two major categories. These two major categories of legal research include applied legal research and doctrinal legal research. Now, applied legal research refers to a type of research that is geared or oriented towards solving a social evil. For example, murder, armed robbery, theft, manslaughter, arson, and all that. That is what applied legal research is all about. Then for doctrinal legal research, this is one that is geared or oriented towards expositions. When we say exposition, it means interpretations of um, legal doctrine. It means interpretation. So doctrinal research is geared or oriented towards exposition or development of legal doctrines. So it simply means that it's geared towards the interpretation and explanation of these legal doctrines. That's what doctrinal legal research is all about. And this includes law reports, statutes, textbooks, legal textbooks, etc. Those are examples of doctrinal legal research. So, for the purpose of this discourse, we'll be focusing on the second category, which is the doctrinal legal research. So, now there are methods of conducting this legal research. So, we need to be abreast of these methods, the procedure for conducting a proper legal research. So, when you want to conduct a legal research, there are certain things you need to have in mind. Because when you go to the law library, where the legal research is conducted in is the law library. So when you go to the law library, you need to know how to locate the particular material that you are interested in researching on. You need to know how to locate that material. So when you go to the law library, you go to the index, because it's in the index where you find whether it is subject index or author or title index. Depending on the type of index you are looking for, you go to the index. And let's say, for instance, now you're looking for the author or title of a book. So you go to the author or title catalog, you go there, then you look for the name of the author, that you're looking for. You look for, if you find his name, then you will now see the call number or the call mark attached to it. So every book in the law library has a distinct call number. No two books can have the same call number. So when you go to when you find the call number, what you should do is to go to the shelf, the particular shelf, and look for that particular book which you intend on making your research on. So once you get the book, then you can now proceed with your research. So if it is a periodical, the method the researcher should use is the stripdex or the cadex. This is for periodicals, and the most used method is the cadex. That is the most used method. So when you get the stripdex or cadex, is where you find the details about the title, the publisher, frequency, days, and all that you can use to easily locate the particular material that you intend on making your research on. So this is what you should have in mind when you are about to go to the law library to acquire a particular material to conduct a research. So now, in the law libraries, there are different types of classification scheme. There are different classification systems in the law library. However, there are two that are the most popular classification system. This is the Elizabeth Moyes classification scheme, or simply the Moyes classification scheme, and the Dewey Decimal classification scheme. So these are the two major. However, in most law libraries, what they use is the Library of Congress classification. That is what is mostly used, and that is what was being used in law for law libraries in the past, before we switched over to this Elizabeth Moyes classification scheme, because this one is more unique. That was the reason we switched to this classification scheme for our law libraries. So this Moyes classification scheme, it was a classification system that was established by Elizabeth Moyes. She was a law librarian and she was born in the UK. So she's the one that developed this classification system, which we are all adopting now in our law libraries. On the other hand, the Dewey Decimal Classification System, in this kind of system, the distinctive feature you can use to distinguish between the two of them is that the Moyes classification scheme makes use of letters, whereas the Dewey Decimal Classification scheme, it makes use of numbers. This one making use of decimals. For instance, now you can see maybe if they are classifying their books, they can make use of numbers like 98, 98.9, 98.7. That is how Dewey Decimal Classification System is. But for law, particularly if it's under the subject structure on this Elizabeth Moyes classification scheme, it is under 16. It is under 16 letters. Under 16 letters. Yeah. And these letters are beginning with K. The 16 of them, they are beginning with K. So the first one we have is K, which is the journals and reference books. Then the next is, because of the best way to understand, to easily recall it, is that the first one is K. Then the second one from A to H, is in alphabetical order. So we have K, we have K A B, K A, K B, K C, K D, K E, K F, K G, K H. And that way you have easily understood the beginning part, because that one is in alphabetical order. But the first K is not without any supporting letter. The first K is not without any supporting letter. It's just on its own. While the next one is KA, like that. So in that order, then the remaining, after KH, then they move over to, after KH, they move over to KL. Then for KL, KM, KN, then we have KP. Then there's KR, KS, KT, KV, KW, and KC. So these are the core numbers. These are the core numbers when we are looking under the subject structure for the Moyes classification scheme. These are the core numbers. And I said there are 16 of them. They are in total, there are 16. So the K is journals and reference book. The first K, journals and reference book. Then the second one is KA, which is jurisprudence. The third one is KB, which is general and companies law. The fourth is KC, which is international law. Then the next, KD, religious and legal system. Then the next, KE, ancient and medieval law. Then the next, KF, primary materials, British eyes. Then the next, KG, primary materials, Canada, US, West Indies. The next is KH, primary materials, Australia, New Zealand. The next is KL, general. The next is KM, public law, constitutional and administrative law. The next is KN, private law. The next is KP, own country. The next is, when you say that own country, it means you put, for instance, now in Nigeria, we put Nigerian law. So the next is KR, Africa. Then the next is KS, Latin America. Then the next is KT, Asia and Pacific. Then the next is KV, Europe. Then the next is KW, European committees, then finally KC, non-legal textbooks. So these are the core numbers under the Moyes classification scheme, and they are very important. They are very, very important, very, very vital. It's because it will enable you to easily know where this particular material you're looking for is. You know under the core number where it is, so you can easily retrieve those. You can easily conduct your legal research. So when we're talking about legal research, we've been saying it's very necessary for a lawyer. A lawyer needs to know how to conduct a legal research in order to prepare his case and defend his client properly. But we need to ask ourselves, where is this legal research being conducted? A legal research is being conducted in a law library. A law library is where legal research is being conducted. And what is this law library? Law library is is the is the location where lawyers conduct their research in order to retrieve legal information so that they can come up with their legal conclusions or make their legal decisions. So the law library is just it could be either virtual or physical, because due to the advancement and the growth of the society, we now have virtual libraries. So it could be a virtual law library. So it is a location where the lawyers, law students, or anybody who is interested or has an interest in the law goes to make a proper research in order to access information that will be necessary for conducting his or her legal research. So this is where the law informations are being stored. That is the law library. So law library, like I said earlier, is very, very essential to the lawyer. A law library is what a laboratory is to a scientist, is what a zoo is to a zoologist. So a law library is also is what a hospital is to a doctor. So a law library is very, very important. So having discussed about the law library, the next one we'll be moving to is the tools for legal research. Now, what are these tools for legal research? When conducting legal research, in the last discussion we had in the last episode when we talked about sources of law, we said that we classify them under primary and secondary. And we say the primary sources of law are the binding sources. They are the ones that the court will always take first and will always lay more and pay more attention to than the secondary sources. So it doesn't then mean that when a lawyer is conducting his or her legal research, that he should now focus more on the primary sources of law and jettison the secondary sources of law. No. For a lawyer to conduct a proper research, he or she must look at the primary sources of law and also the secondary sources of law, because both sources of law are very important. In as much as the primary sources is more binding, the secondary sources can widen our knowledge on that particular subject and even give us more ideas that can be added when presenting your case. For instance, you are trying to defend your client, it can be able to make your case to be more more authentic, and it shows that you conducted a proper legal research. It shows that you are well equipped with the knowledge of the law, because even these law journals, these digest periodicals, these articles also, because they are written by seasoned authors, they are written by people who are well equipped with knowledge of the law. So these are the primary sources of law, that the undiluted explanations of the law, because they include the statutes, the precedents, legislation and all that. Whereas the secondary sources, these are the ones that have been diluted because the aim was to expatiate and explain, okay, what is that particular legal principle talking about? So here different jurists, philosophers have given their own idea, which, like we have agreed, is persuasive. So if you're conducting a legal research, you must look at the primary source and the secondary source. And a good law library is one that contains the primary sources of law, the secondary sources of law, and also non-legal textbooks, because non-legal textbooks are also fundamental for a standard library. And in Nigeria, a library needs to be very standard in order to receive accreditation. If, for instance, in Nigeria, the NUC and the um, um, legal council for education, they come to investigate the law faculties in Nigeria to make sure that they are up to standard before they can enable them to admit law students that will come to the law school. So if the law library, like it's already stated that even if the faculty is in good shape and the faculty is well equipped, everywhere is very neat and well organized, but the law library is inadequate. The law library it lacks the necessary materials. Such a university would not be given accreditation for that year, and is a very major setback for that university. So law library is very essential, and it must consist of these three groups: primary sources, secondary sources, and non-legal materials. That is how a standard law library is. So still on the legal research, we have identified that there are primary and secondary sources. So law reports are also primary sources. Law reports, as we all know, this includes law reports is where previous cases have been cited and they have been recorded. So law reports is what is enabling us to practice these judicial precedents, because without these law reports, there's no way we can be able to recall every case that has happened in the past, because some cases happened before we were born. So without the presence of these law reports, we may not be able to be knowledgeable of these cases and what the decisions of the courts were in that cases. So it ensures predictability, because with judicial precedents you can predict what the decision of the court will be as far as those cases are of similar facts. In case law, for the court to follow judicial precedents, the case must be of similar facts. Once there is any difference in it, we cannot say the case is the same, or the judge should give the decision that was held in that previous case. The case must be of similar facts. So we have different kinds of law reports. We have the All Nigerian Law Report. We have the Nigerian Weekly Law Report. We have the Law Pavilion. There are so many law reports. There are so many law reports. So those are the law reports. Then we also have digest and periodicals. These journals. Journals. These are they are either made weekly, bi-weekly, monthly, or annually. They are published. They are published in that manner. So they are gradually gaining momentum, and more people are producing more periodicals and more journals. So legal textbooks, these are what we use. For instance, students will use legal textbook to be able to learn more about our courses and also make research. So these are just the sources of law. They are the tools. All these are the tools for legal research, and they are very, 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 very important. And so there are also methods also for effective and efficient research. And they have the subject method and we have the case method. The subject method is the use of the subject headings. to make a research. For example, if you are trying to find a material under, let's say you're trying to find a material under arbitration, so you go you will go to the index and look for um you look for where arbitration is. Then you when you get when you see the arbitration, then you get the call number and go to the particular shelf where you can retrieve the material. So is a kind of method where materials are being searched for via their subject. So if you are using the subject method, you will look for the particular subject. If it's criminal law, if it's Nigerian legal system, you use that particular subject. And we have the case method. The case method here, you use the name of the parties. The name of the parties to search for the case. You can either search it for in the index of a law textbook, or you find it in the law reports in the table of cases. So, but if you have the full citation of the case, you can easily go straight to the law report and look for the case, because you will find it in full detail in the law report. So it's best that you use the law report if you have the full citation. So with this, we have an overview of what legal research is and why legal research is important, and how to conduct legal research in a law library. So I hope this discussion was as educative as possible. And in our next episode, we are going to discuss on legal writing in our next episode. So do well to stay tuned, follow this our podcast, share to your friends and family, like, comment your opinions also, and we hope to see you again. My name remains David Njoku, and like I always say, this podcast is for educational purposes. I am not a lawyer, so do not take any of my wordings here for legal advice. If you need proper legal advice, consult a legal practitioner. So thank you once again, and I hope to see you again. Have a nice day.